Good evening, everyone. Thank you so much for joining us tonight for our family webinar series hosted by the UIC Division of Specialized Care for Children, DSCC for short. I am Yariela Ramirez Vecchio, and I am a member of the DSCC team. Tonight, we are diving into an important topic, state and financial planning. As I mentioned at the beginning, the SEC is proud to host this webinar series. Our vision is that children and youth with special healthcare needs and their families are at the center of a seamless support system that that improves their quality of life. The SEC mission is to partner with Illinois families and community to help children and youth with special healthcare needs to connect to these services and resources. Um, Part of our goal is to connect everyone to resources, is to do webinars like this, where we give the community and families information directly on topics that are most relevant for you. Our presentation tonight will be in English, so the slides you will see will also be in English. If you select Spanish interpretation, you will hear the presentation in Spanish. We have also posted both English and Spanish version of the slides on the DSCC website. If you would like to follow along or review them later. Also, everything we are covering is accurate as of today. So if you are watching the recording later, just keep in mind that some details may have changed. All right. Now that we have taken care of all the housekeeping, I'm excited to turn um, it over to our wonderful presenter, Tim Rigby. Thank you so much for being here and share this information with us. Feel free to go ahead and share your slides whenever you are ready, Tim.
Well, good evening, everybody. My name is Tim Rigby. I'm an attorney at the law firm of Hart, Southworth, and Witsman in Springfield. I practiced in the area of estate planning for my entire legal career, but a little over 22 years ago, something changed in my personal life that drastically affected my professional life. In January 2004, my wife gave birth to our third child, our daughter Anna, and Anna was born with Down syndrome. After Anna was born, I started focusing my practice on special needs estate planning and guardianship. When I first started working in this area of law, I did so in order to help my own family. And like many of you, I began this process by asking myself, if my wife and I are not here tomorrow, then what will Anna's life look like? How will she be able to support herself? Who will take care of her? Who will take care of her personal and her financial needs? I had to figure all of this out so that we could leave Anna some of our assets when we're gone and place someone else in charge of managing those assets, while at the same time not disrupting any financial assistance that she might otherwise be able to receive, assistance like in the form of government benefits. I started doing research to help answer some of these questions, and I fumbled my way through it and eventually figured out how to prepare an estate plan for my family. And then I realized that there are a lot of other families out there like ours who could really benefit from the things that I had learned over time and that I continue to learn every day. So I've had the privilege over the years of working with a lot of families who have family members with disability. And I really enjoyed speaking with groups like this so that I can pass along some of the things that I've learned. Several years ago, I had the honor of being invited to join the Special Needs Alliance. The Special Needs Alliance is a national organization that has about 200 special needs estate planning attorneys throughout the country. Special Needs Alliance provides a lot of educational resources to its attorneys and also to parents of children with special needs. The Special Needs Alliance published the handbook that I've included tonight in your handout material. and it has a really great website. I've included the link to the website on the screen. The website includes a blog and articles written by attorneys for families covering a number of topics and written in a way that people who don't do this every day can understand. I would encourage you to check out the Special Needs Alliance website. And with that introduction out of the way, let's jump into our program. So we're all here this evening to discuss special needs estate planning and how that sort of planning may affect your child's eligibility for government benefits. We will certainly get into special needs estate planning. That again is the main reason we're here this evening. But before we do, I want to spend a few minutes discussing estate planning in general. Without a basic understanding of estate planning, it will be difficult for me to explain the benefits of special needs estate planning. So what is estate planning? Generally speaking, estate planning is a way to pass assets from one person to another upon a person's death. Estate planning becomes especially important if your assets would pass at your death to a person who has a disability or a very young person, a person who may not be very good with managing money. Perhaps that person has creditor problems or a marriage, a bad marriage that could end up in a divorce. Or maybe they just have something going on in their life that makes inheriting assets directly not such a good idea. And so through proper estate planning, you may be able to provide your loved one with financial support and financial security possibly for their entire lifetime, even though they may have some of these things going on. So let's face it, none of us know what tomorrow may bring. And the fact is that any one of us may not be here tomorrow. So when I work with clients on estate planning, I encourage them to think first about planning for tomorrow and the possibility that something could happen in the very near future, rather than necessarily thinking in terms of 5 years, 10 years, or 20 years from now. Of course, it is important to not to lose sight of the long term, but you should also bear in mind the short term in your planning. I assume that most of you are here this evening because you have a child with a disability. But I also assume that many of you also have one or more children who do not have a disability. And our discussion this evening will not be limited to estate planning for our children with disabilities. Depending upon your situation, your estate planning may be as important for your children who do not have disabilities as it is for your child who does have a disability. And so I first want to discuss why it is critically important for us to do estate planning for all of our children, regardless of whether or not they may or may not have a disability. For the sake of our discussion this evening, I also assume that you do not have an estate plan in place already. For example, maybe you've not yet prepared a will directing how your assets are to pass upon your death. If that's the case, then that's okay, because the state of Illinois has a plan for you. The estate plan is that's provided by the state is set out in the Illinois Probate Act. And at your death, your assets will be divided and distributed according to the instructions contained in the Probate Act. Under the Illinois Probate Act, the person who would receive your estate if you do not have a will is known as an heir. The Probate Act describes who your heirs would be and what portion of your estate each of your heirs will receive. The Probate Act has a section that addresses how your assets are divided among your heirs under various scenarios. For instance, if you have a spouse and children, or you have a spouse but no children, or you have children but no spouse, or you have no children and no spouse, that's all described in the Probate Act, and your estate is allocated accordingly. Under the Probate Act, any heir who is 18 years of age or older would receive his or her share of your estate outright. And as we'll discuss this evening, that may not be such a good idea. Assuming that you do not want to rely entirely on the Illinois Probate Act to direct how your estate would pass, then we look to other options. One of those options is a will, and most people are familiar with wills. A will is the most basic form of estate planning. With a will, you can direct how your assets will pass, and in your will, you might say something along the lines of, everything goes to my spouse if my spouse is living. If my spouse is not living, then everything goes in equal shares to my children. That's pretty common planning. But in my opinion, in many cases, neither of these options, either the estate plan contained in the Illinois Probate Act or a simple will alone, are the best option for most people. And we usually do not stop, in our estate planning, we do not stop with the will alone. Here's why. If a person's spouse is not living when that person dies, then most people provide in their will that their estates, their assets will pass to their children. If a children is deceased, their estate would pass to their children, but if a child is deceased and has children living, then that deceased child's share will often pass under the will to that deceased child's children. So a will alone often contemplates that the assets will pass outright. If a child or a grandchild who is to receive something under the will is under the age of 18, then assets would pass to that child or grandchild would be handed over to a court-appointed guardian for that child or grandchild. And the guardian would then manage those assets until the child or grandchild turns 18. But when the child or grandchild turns 18, that person's share will be distributed outright to that person without any restrictions. At your death, if your children are older, are all living and are all financially responsible, meaning that they make good financial choices, then this type of instruction may be okay. But in reality, as you sit here today, you don't know that your older, financially responsible children will all be living on the date of your death. So the biggest problem with the will alone is that it often does not direct that assets will be held for a long period of time or for a period of time to allow for distribution when your child or your grandchild reaches a little more financially responsible age. When talking to clients about estate planning, I always encourage them to think back to when they were 18. When you were 18, if you had money dropped in your lap, how responsible would you have been? Would you have invested it? Would you have saved it for retirement? I know that I sure wouldn't have. I probably would have bought a car, gone on a nice trip, and within a few years, the money would have been gone. And so it's for that reason that I incorporate typically another document into almost every estate plan that I prepare for clients. That document is called a trust. With the trust, you can direct someone of your choosing, called a trustee, to hold assets and to distribute those assets over time to your children under the terms that you decide and you set forth in your trust. Often a trustee of a trust would have some discretion regarding distributions to be made from the trust. That discretion usually comes in the form of a statement that distributions can be made for a beneficiary's health, support, and reasonable comfort and education. And that's a very broad standard. It gives your trustee some flexibility to decide how the assets will be spent within that standard until your child reaches a little older, more financially responsible age. We also typically include what we call staggered distribution language in our trusts. That language provides that a young trust beneficiary cannot withdraw from the trust assets all at once, even after they've turned 18. Rather, they would only be able to withdraw assets from a trust slowly over time. We typically incorporate in our staggered distribution language something along the lines of the child can withdraw 1/3 of the trust at age 25, another 1/3 of the trust at age 30, and the final 1/3 of the trust at age 35. And between those ages, your trustee would continue to have discretion to distribute to that child under that very broad standard, but your child would not have the right to withdraw from the trust. Now, I overstated just a little bit earlier when I stated that under a will, assets must be distributed all at once. In reality, trust language can actually be incorporated into a will itself, or a trust can be a standalone document. When trust language is incorporated into a will, the trust that's established is known as a testamentary trust. When it's a standalone document, like I typically use, it is known as an inter vivos trust. Again, I typically work with and use standalone inter vivos trust with clients because that sort of trust has other advantages over a will and over a testamentary trust created under a will. For example, a standalone trust can avoid a time-consuming and expensive probate or court administration of an estate, and it can also reduce or eliminate estate tax. These topics are outside of the scope of our discussion for today, but the main takeaway with regards to this portion of our presentation is the importance of considering trusts in general as part of your estate plan for one reason or another. With that brief primer on estate planning in general, we can now turn our attention to planning for our children with disabilities. We have to plan for our children with disabilities a little differently because a person with a disability may be eligible to receive government benefits at some point. Eligibility for government benefits often depends on whether a person is able to hold a job and earn a living. If they are not able to hold a job or earn a living because of that disability, then they may very well be eligible to receive government benefits. And the government benefits for our children with disabilities often comes in two forms, Social Security Supplemental Income, or SSI, and Medicaid. SSI provides a monthly stipend, and for 2026, the amount of that stipend is $994 per month, while Medicaid covers a lot of medical expenses and also housing and vocational programs. For example, community-based housing like group homes, sheltered workshops, day training programs, job coaching, etc. And depending on the services received through Medicaid, that benefit can equate to $100,000 a year or more, through the benefits you receive. So in order to be eligible for these means-based or needs-based government benefits, government agencies look at a person's income and also at their assets. A person cannot have too much income, and the calculation of income of the income threshold is complicated. It's based upon earned and unearned income, and various exceptions and exclusions from countable income. And again, that's beyond the scope of our discussion today. But from an estate planning standpoint, I really focus not so much on income, but on assets, because of the possibility that a person can inherit assets. Again, a person cannot have too many assets at one time. And if they do, then government benefits can be reduced or eliminated. The asset threshold is $2,000 in total. This $2,000 asset threshold was established in the early 1970s, and the federal government has never increased the amount of that asset threshold. In today's dollars, that asset threshold would equate to something along the lines of $25,000 or more. So the federal government has really created a situation where it promotes or encourages the people with disabilities be impoverished because they can't have more than $2,000 and still qualify for benefits. So we must keep in mind that assets that a person with a disability might own that could count against them for purposes of their government benefits eligibility would include assets that a person would inherit from a family member. So the primary purpose of special needs estate planning is to help ensure that your child may someday be eligible to receive these government benefits, even though they may inherit assets from you having a value over that $2,000 threshold. From an estate planning standpoint, our primary goal is to ensure that assets that are inherited by a person with a disability don't count against that person and prevent them from receiving their government benefits. But we're also sensitive to the fact that the government benefits alone will not be enough to support them. Let's face it, that monthly stipend received through SSI is not a lot. Without other assets available to your child to supplement that government benefit, your child will only have $994 per month. And from that, your child will have to pay for all of his or her rent, food, utilities, clothes, insurance, entertainment, vacations, and so on, other than medical expenses, which again are usually paid through Medicaid. But that $994 per month is probably not enough for your child to live the quality of life to which they've grown accustomed over time. They may be able to pay for some necessary things like rent, utilities, and food, but they probably won't have enough with the government benefits alone to pay for many of life's luxuries like entertainment, vacations, clothes, haircuts, a car, or even gas to put in the car. These items will largely be unattainable. And they will need some help they will need some help to supplement that income and allow them to fund a better quality of life. You probably help them with that today, and you will probably continue to help them as long as you are able. But what happens when you're not here to provide that help? That is where special needs estate planning comes in, and that's what it's really all about, helping to fund your child's quality of life when we're not here and able to help provide that extra financial support. If you want to help your child continue to live a good quality of life, then you will need to continue to support them even when you are not here. And that means leaving some assets to them when you're gone. But that's where we have the dilemma. Remember, the government benefit asset threshold is $2,000. That threshold effectively prevents us from leaving assets outright to our children or even leaving them assets in the traditional trust that we discussed earlier. So what do we do? What options do we have here? One option is we could just not leave any assets to our children or to our child with a disability. Again, that's not such a good idea because, as we've discussed, the $994 per month stipend is really not enough to pay for the things in life that they'll need. They need that additional financial support in order to live a quality of life. So we've already established that. We could leave assets to another child or another family member and have that person then use those assets to take care of the child with a disability. I hear this strategy a lot, and I really, really don't like it. There are a number of reasons that I believe that this is very bad planning. You don't know what will happen to the person to whom you're leaving your assets. That person could die before your child with a disability. Then the money that you've left for your child with a disability would go to that person's own heirs, and not necessarily to your child with a disability. What happens if that person doesn't follow your directions, or that person has creditor problems, maybe a failed business or credit card debt? That person could have a bad marriage and have divorce problems and a spouse that takes their assets upon a divorce. That person may have a family of their own and just choose not to spend those assets on your child with a disability and instead spend them on their family. So again, I really don't like that strategy when I hear it from clients. Another option would be to just go ahead and leave your assets to your child with a disability and forego those government benefits. That could make some sense if you're wealthy enough that the money that you're able to leave, is enough to support them, and you don't need the $994 a month from SSI. That $994 a month really isn't that much in the whole scheme of things, considering all of the things that your child will need. But Medicaid isn't, it's not really the best medical benefit, but it's important to have. And many of the programs that people participate in are, people with disabilities are tied to eligibility for benefits. For example, day training programs, vocational programs, housing programs. Some of these programs a person can only participate in if they receive or are eligible to receive government benefits. So there is a better option. There's another type of trust that we can establish for our children with disabilities. That trust is known as a special needs trust, or sometimes a supplemental needs trust. Assets held for a person with a disability in a properly drafted special needs trust do not count against that person for benefits eligibility purposes. Government agencies have blessed this type of a trust, and you can direct in your other estate planning documents that any assets that would pass to your child with a disability do not pass to that child directly, but instead go into the special needs trust that you've created. That special needs trust has some magic language in it. That language describes the fact that your child has a disability that may make them eligible for government benefits, and that you've established the trust to supplement those benefits, but not to replace those benefits. It also provides that the trustee has total discretion in how the trust assets are spent, and that your child doesn't have a right to withdraw from the trust. With a special needs trust, you appoint someone known as a trustee to hold the assets for your child and to spend those assets on things that won't disqualify your child from receiving benefits. If that trustee is not a person who's in your life day in and day out, or who may not be completely familiar with your child's needs, as in the case of professional trustees like a bank or a trust company, then you can also name someone in the special needs trust to act as a consultant to advise the trustee of your child's daily needs. Special needs trusts are only valid and do not count against the asset threshold as long as the trust assets are not spent on your child or the beneficiary's primary support. That means that the special needs trust assets cannot be spent on shelter or housing related expenses, things like rent, utilities, property taxes, property insurance. until recently, you also couldn't spend trust assets on groceries or food. But the Social Security Administration recently removed food from the list of excluded assets. The rationale here is that the government benefits are used to provide for the primary support, again, for your child's housing related expenses. And the Special Needs Trust is created to supplement that primary support and not to replace it. That is why leaving assets to your child with a disability through a traditional trust could jeopardize those benefits. Remember back to the beginning of our discussion this evening when I mentioned that a traditional trust has language that provides how distributions can be made from that trust. And the most common distribution standard is for the health, support in reasonable comfort, and education of the trust beneficiary. It's that support language in a traditional trust that would get us in trouble for leaving assets in a traditional trust to our children with a disability. But a trustee of a special needs trust can spend the assets of the special needs trust again to supplement those government benefits, to buy things like clothes, furniture, TV, vacations, haircuts, entertainment, medical expenses, medical adaptive equipment, vehicles, those sorts of things, all sorts of things, just not housing related expenses. By establishing a special needs trust, you can help your children bridge that gap between merely surviving and truly living a good quality of life. You can provide your child with a resource to supplement his or her government benefits and pay for those things that will help them live happily when government benefits alone are not enough. When I talk to a lot of clients about special needs trusts, I often hear something along the lines of, I don't have many assets. I don't think that I need to do estate planning, or I don't have enough assets to warrant developing a trust. And I usually respond by reminding my clients that a person with a disability does not need to have much through their inheritance to disrupt that person's financial security. Remember, if they receive as little as $2,000 through an inheritance, then that could cost them tens of thousands of dollars in the form of lost government benefits. And proper planning doesn't have to cost a lot to set up. It usually does not cost nearly as much as people believe that it may. So I've left quite a bit of time tonight for questions and answers. I hope I thank you for attending. I hope you've learned something and that I haven't bored you to tears. But again, at this time, I'll turn it over to any questions you might have.
Tim, it looks like there's one in the chat right now that says, what about needs to pay a daily caregiver? I believe that was that was asked during the last slide that you had up. Maybe if that could be used.
Yep. So generally speaking, yes, special needs trust can be used to pay for caregiver services. There are a lot of things that special needs trust can be used for, and paying for caregiver services is certainly one of those.
Another question that was put in the Q&A that says, can we put a monetary inheritance directly into an ABLE account?
Yeah, so let's talk about ABLE accounts. That was a little outside of the scope of tonight, but not a lot. And so ABLE accounts are a very important tool, very useful tool in estate planning. ABLE accounts were established by first the federal government in 2014, and they basically allow a person with a disability to have assets in an account that they have the ability to access, and those assets don't count against them. In fact, we use ABLE accounts, kind of in tandem with our special needs trusts. There's a little bit of a workaround that we build into the special needs trust, specifically relating to the housing related expenses. So remember, with the special needs trust, you can't allow the person with a disability to have direct access, and you can't allow the person with a disability or the trustee can't spend those assets on housing related services. But we do provide in the special needs trust that a trustee has discretion to distribute out into an ABLE account. And an ABLE account can be used for housing expenses. So that's kind of the workaround. The trust can provide that a trustee can distribute out to an ABLE account but the ABLE account, and then the ABLE account can be used for some of those housing related expenses. But there are some drawbacks with regards to ABLE accounts. So an ABLE account, you cannot contribute more than $20,000 in any 1 year to an ABLE account. That's a new change. It's up from $19,000 last year. And so that's what often prevents us from using ABLE accounts as the primary estate planning tool, because a lot of times the estate that we might leave to our children with a disability will exceed even that $20,000 annual contribution limit. The other thing is with ABLE accounts, if the total account has a value of over $100,000, then anything over 100,000 starts to count against the child for their government benefits purposes. Another disadvantage with an ABLE account is that until this year, an ABLE account was only available to a person who had their disability onset age, usually determined by Social Security Administration, at age 26 or earlier. And so a lot of people were just disqualified from even opening ABLE accounts because their disability onset age couldn't be proven until after age 26. Effective January 1 of this year, that age 26 has increased to age 45. So that's certainly been helpful. But so hopefully that answers your question. ABLE accounts are a great tool in our toolbox, but they're not what I would consider to be the primary vehicle for estate planning.
Okay. Another question is, and maybe this is related to something else you were saying, but it says you said a special needs trust or an adapted special needs trust. I don't know if there is any distinction there.
I don't think I said adaptive special needs trust. So there's special needs trusts. Sometimes they're referred to as supplemental needs trusts. So I use those two terms interchangeably: special needs trusts and supplemental needs trusts.
Can there be more than one trustee?
Yeah, absolutely. You can have multiple trustees called co-trustees. I often encourage clients to consider very strongly, having multiple trustees, because sometimes having more than one person can make it a little unmanageable or difficult to work with, particularly if you've got two people located in two different parts of the country, or maybe two people that don't agree with each other perfectly. So it's always one of those things you got to really think hard about when having co-trustees. The other thing I also encourage clients to consider with special needs trusts is at least consider having a professional trustee appointed, a bank trust department or a trust company that specializes in special needs trust and special needs trust planning. The reason for that is that these special needs trusts are a little different animal than a regular trust in terms of how they're administered, how the assets can be spent, and those sorts of things. Remember, we talked earlier about how with a special needs trust, a trustee has total discretion on distributions. They can't distribute for things like housing related expenses. And so you've got to be just a little careful, in terms of how you're making distributions. You also have to report those distributions to the government benefits agencies, Social Security Administration and the Medicaid agencies. And so if a person doesn't have that education or experience in how to administer these things, then they can get cause trouble in terms of potential loss of government benefits if they don't administer them properly. So I at least encourage clients to consider having a trustee that's a professional that knows this, has experience in this area and works in this area, day in and day out.
I think another question was, and anyone we choose can be the trustee, which from what you're saying, it sounds like yes, but maybe with caution.
Yeah, absolutely. Anyone can be trustee, but with caution. Again, I would encourage you to consider very carefully who you're appointing as your trustee. And most of the trusts we do have individual or family members acting as trustees, but I always again kind of make make a point of explaining and making sure that the client understands the need to have somebody that maybe they don't have that direct experience or education, but at least have the ability to comprehend and learn and understand, what can and can't be done with the trust.
A lot of questions for you tonight. So we're going to
Yeah,
get through as many as we
absolutely.
can.
Absolutely.
Once a special needs trust is established, can a trustee cancel the trust if the child with special needs becomes capable and those funds are able to be distributed to that child?
Sure, yeah. And so there's kind of a lot to unpack with that question. So one of the things that I would point out is that typically the trust, at least that I create, the special needs trusts for clients, they're created as revocable and amendable trusts. And the reason I do that is because a lot of times I'm meeting with clients who have very young children, and they themselves are young, and over the course of their lifetime, there may be changes. There may be changes in who would be appointed as the trustee, or changes to the trust to adapt to changes in the law. And so we make our special needs trust typically amendable and revocable. And the other thing is that the special needs trust, it can be used again, for a lot of different purposes. There's language in there that says that the trustee should not use the assets in a way that's going to jeopardize government benefits. But there's kind of companion language that also says that despite the first language, the trustee has the discretion, the complete discretion to make distributions for the benefit of the beneficiary, even if it might jeopardize those government benefits. And so usually with that broad discretion, a client could use the special needs trust as just a regular trust if the child doesn't qualify for government benefits, and simply utilize the trustee discretion to make distributions. But again, one thing to point out is clients who have children with disabilities, and particularly clients who have very young children with disabilities, where they don't fully understand or appreciate how those disabilities will manifest themselves later in life. They want that flexibility, and they need that flexibility. And so these trusts have that flexibility, but oftentimes those clients will agree that even though that child may not someday qualify for government benefits, they will probably always need some financial help or help with managing their finances. So we oftentimes have language that says, that the trust can be used for distributions for the child under the trustee discretion, but the child doesn't have the right to come in and withdraw during that child's lifetime. So, again, I hope that answers the question, but very definitely the trust is amendable and revocable and can be modified if later in life the child doesn't need those needs-based government benefits.
Maybe a slightly related question. What happens to the money in the trust when the disabled individual passes? Is there a beneficiary on for the trust in that situation?
Yeah, and so this is interesting, and I'll also provide some kind of companion information relating to what happens in situations where people don't plan for their child with a disability. So very definitely the special needs trust, what we're describing tonight and what we're talking about tonight is what we call a third party special needs trust. The reason it's called a third party special needs trust is it's created by a parent or a grandparent or some other family member, typically for that child with a disability, to leave that third party's money into, to leave the parent's money or the grandparent's money or assets. And so it's a third party trust because it's receiving third party money. And as a third party trust, the person creating the trust can very definitely, and this is the big advantage of these things, they can provide for what happens to those assets if the child dies and there are assets left in the trust. It can provide that it goes to other children or grandchildren or other family members. And so the third party special needs trust provides just that. Now, the major difference between the third party trust and a different kind of special needs trust called a first party special needs trust or an OBRA trust is that the first party trust has to contain language that says that if the child dies and there are assets in that first party trust, then those assets have to be used to pay back Medicaid to the extent of Medicaid use. And the difference in these types of trusts, the first party trust versus the third party trust, usually is based upon when we create them. So, for instance, if you as a parent are creating in your estate plan a third party trust and directing that your assets would be left to that third party trust, that's the type of trust that can have that language that would allow assets to pass to another family member at the death of your child. But if you don't do any planning at all, and your child would inherit your assets, for instance, through the Illinois Probate Act that we talked about earlier, or through your will, and we realize after you're gone that this person with a disability who otherwise is on government benefits now all of a sudden has inherited assets in their own name. Well, that doesn't mean that they lose their benefits. What we can do in that case is come in and establish a first party trust for that child to put those benefits, those inherited assets into, but that first party trust has to have that payback language in it. The first party trust is also a little more complicated in the establishment, and so it's a little more again, a little more time consuming, a little more expensive to prepare than is the third party trust. So I hope that answers that question.
Is there any restrictions with a special needs trust?
Yeah, what we talked about earlier, the ability, how the assets are spent, that they can only be spent on certain things, that do not include, housing related expenses. They can't allow the child to have direct access to the assets and withdraw directly from the trust. So yeah, there are very definitely some restrictions. And so again, it's not the most perfect planning, because in a perfect world, we would leave assets to our child to be able to use at our child's discretion, maybe with some help with, from a financial planner or financial advisor. But we just can't do that because of the government benefit eligibility.
Any problem with having a trustee that lives out of state?
No, and we do that a lot in today's day and age with with internet banking and debit cards and credit cards and those sorts of things. We have a lot of situations where trustees, and sometimes trustees of special needs trusts don't live, very close to the beneficiary.
I think you briefly touched on this, but is there a Medicaid payback rule with revocable and amendable trusts?
If it is a third party trust that a person is leaving assets to that are not the assets of the person with a disability who's receiving government benefits, then there's no need to have a Medicaid payback requirement in the trust. So again, just touching a little more on what are third party assets versus first party assets. Third party assets would be, if my wife and I are doing an estate plan and we're leaving our estate, the money that we have earned over time, or the assets that we have accumulated over time, we're leaving those to our daughter Anna in a special needs trust. That's a third party trust because it's third party assets. It's not our assets. I had a client many years ago who had an account that they created this third party trust, and they went ahead and funded it while they were living, which we often don't necessarily recommend, but they moved assets from this account into this third party special needs trust. And the next thing that happens is their child loses their child's government benefits. And when we went to the Social Security Administration to figure out why, the Social Security Administration pointed to the fact that account that they moved into the third party trust was a commingled account that included assets of both the child with a disability and the parents. And it was the commingled money, the child's own money, that jeopardized those benefits. And so examples of first party money that we use to fund first party trusts that have to have the payback language would be a child who has maybe a birth related medical injury that results in a judgment or a settlement, or an inheritance. What I work in most often, somebody who doesn't do this special needs estate planning and inadvertently leaves assets to their child. I've had a couple people over the last year or so where a person with a disability who's otherwise receiving government benefits gets in a car accident, and with that car accident, they receive a medical settlement for injuries they sustained, and we've had to create the first party trust that has the payback language in those situations, because those assets are the assets of the child, not the assets of the parent.
Is there any other account that won't count against federal or state benefits, but can be used toward rent or residential placement for a special needs child?
Boy, again, we talk about ABLE accounts, restricted accounts. I'm not aware of anything other than an ABLE account that would be, eligible for the child. But again, I don't hold myself out to be a benefits eligibility expert. I'm not the one who knows what the benefits eligibility rules are verbatim. I often refer clients with questions like that to a social services agency or person who handles more of the benefits eligibility side. We have one in Springfield that's terrific. I know other communities have them, but there are agencies and people out there who handle those benefits eligibility issues directly.
Can a 529 investment be used to transfer to ABLE accounts as needed? Is there
you can convert a 529 account to an ABLE account. That's kind of some legislation that I think is relatively new, but I've seen some things on that where we're now able to have, and parents do this a lot. They'll establish a 529 plan for a child when that child's very little, and then and then the disability manifests itself, and all of a sudden we've got this 529 plan for an 18-year-old who qualifies for government benefits, and the 529 plan, it gets in the way of those benefits. So there is an ability to convert that 529 plan into an ABLE.
Is an ABLE account considered first party money?
Well, an ABLE account is first party money. Yeah, it's the child's own money, but it's money that doesn't count against them. So even though it's first party money, because it doesn't count against them, we don't need to worry about Medicaid payback language. Interestingly, the ABLE account under the federal legislation, the ABLE account as it was initially established, provided that if there's money in the ABLE account at the person with the disability's death and the person used Medicaid, then the ABLE account was supposed to pay back Medicaid. But many states, including Illinois, has not enforced that Medicaid payback language with their ABLE accounts. So Illinois, at this point at least, is still not enforcing that Medicaid payback. I can't guarantee that that's always going to be the case, but to this point, that's been the case.
This may be our last question that we could get to, and maybe a good question to end on, perhaps, as we wrap up. What would you recommend as the best first steps for parents to start to create a comprehensive plan and ensure, knowledgeable professionals?
Well, I would say certainly reach out to an attorney who has experience drafting special needs trusts. There are a number of them in Illinois who are in the Special Needs Alliance. We know that Special Needs Alliance attorneys have that experience. Again, if you look at the Special Needs Alliance website, you can there's a tab that you can pull down and locate an attorney. There are a number of them up in the Chicago area. There's I'm kind of in the middle part of the state. We have another one in the southern part of the state. But certainly, make sure that you're the attorney that you work with in drafting, and an attorney doesn't have to be in the special needs alliance. There are a lot of great attorneys, estate planning attorneys out there who do special needs estate planning. Just make sure that they have experience in that area and have drafted special needs estate trusts and estate plans in the past, and done it successfully. Also work with your financial advisor. Your financial advisor often has contacts, for people who can help with this area.
Great. Thank you, Tim.
Yeah.
There's certainly several other questions in the chat. But if it's okay with you, Tim, I might take those back, kind of see if I can compile them. And maybe we can email some just basic information out to everybody after the webinar, just answer a few of them through email.
Absolutely. Happy to help.
Okay, wonderful.
And again, thank you everybody for attending tonight. I hope you were able to get something out of this.
Yeah, it was really great information. I'm sure a lot of information, but really great information. Yadi, do you want to throw the slides back up and we'll just cover the last few things that we have to wrap up?
Okay, as we wrap up, thank you all for taking the time to join us today. We hope you found this presentation helpful. As a reminder, all the materials will be posted on the DSCC website. The recordings may take a few days to be ready, but it will be posted as soon as it is available. When you have the Zoom, when you exit the Zoom session, it's a short survey will pop up. So please take the time to fill it out. Your feedback is very important to us and help us plan future webinars on topics that matter most to you. This is a webinar series, so we have one for March, April, May. All the materials and recordings are posted on the DSCC website. You could also register for any future webinars on the DSCC site. Finally, if you did like to connect with DSCC, you can reach us by phone, email, or through our website. You could also follow us on Facebook, Instagram, LinkedIn, and YouTube. Thank you again for joining the webinar, and we hope you have a wonderful rest of your evening.